It shows you that the reason you're getting nowhere in your case, unless you've got a good lawyer that's actually deciding to do it by the books, okay, the reason you're getting nowhere is because of the fact that the longer they keep you on their books, the more money they make. And so, yeah, there's less that you don't have to go and get as many clients because you're milking the system that way. But the reality of it
is a suction cup on their fucking head and get milked.
Yeah, exactly. And what it comes down to is this, okay? You can have a family court lawyer that's legal aid appointed to you, okay? What you will manage to get them to do in 9 to 12 months, okay, if you manage to get them to file, because we all know the old story of, okay, you want to get this done, yep, we'll get that application done. 5 months later, the application finally goes in. Then you might get a court date next year, okay? So the difference between that and self-representing, okay, is that 5 months where you've asked your lawyer that first day, okay, you put that form in yourself, and within 48 hours you will get a date, because the minutes are done within 48 hours. The reason it is not 48 to 72 hours, the reason it is taking you so long to get into court is because of the fact that your lawyer just doesn't do the application, okay? We had a case where the lawyer had put in for a discharge application. Now, here's the problem you got. They put a discharge application in, which is a section 125. Okay. But until you do the memorandum in regards to it, you don't receive a date. Okay. Now, when you've got a lawyer that applies for one in July last year, and then you question why it's taking so long to get a date, oh, well, I haven't put the memorandum in yet, in October. So the child has to
they should go in at the same. They should go in at the same time, yeah.
If you're filing yourself, yes, you put everything in at the same time. But okay, by not putting a memorandum, you purposely delay getting a date. The memorandum is saying to the judge, we would like a date. Okay, and so what happens is when the memorandum goes, you've got to serve all the other parties so that they're aware. Okay, and then a date comes out in the minutes. And so because whānau out there are not aware of that. And like originally, we weren't aware of this either. Okay, but when you can talk to a lawyer for 9 months, okay, and you're getting nowhere, okay, and then over a 4-week period, you file everything that you've asked the lawyer to file, okay, and within 2 of those weeks, you've got dates. For 2 of those applications, you've got dates, okay, then you know that they were screwing you around. And you know, at the end of the day, they don't. Yeah.
It's a lot less harm to the child if you're doing it yourself, because they aren't 6 months or a year away from their parents, because you're speeding things up doing it yourself.
And I honestly believe that even though, like with our whānau's case, even though the uplift happened in March, if at that time we hadn't listened to the advocate we had, I honestly believe that in our case she would have been home in June, because that was when the first hearing was going to, hearing was going to be for the discharge, but we got asked to pull the application out so that we could go for a hui whānau and discuss it with them to collaborate. Didn't work that way. You know, so realistically, I honestly believe that because, you know, one of the people there mentioned it happened to overhear them saying, I don't know why they pulled it out, they would have won. Okay. So it would have been one of the fastest cases in OT history. You know, from what was it, April 27th to June 5th. That would have been one of the fastest cases ever. But, you know, and so, but they have no, like all of these people in the system have no interest in the child. They have no, the Act goes on about well-being and best interest, and safety is paramount. But none of them give a shit about that. Because at the end of the day, if they did, nobody's going to turn around and have a go at someone who says, made a mistake. Okay, I'm sorry it happened. Here's the child back. But the system doesn't have the balls to do that, because that means we got to admit we were wrong, and we've already got six decades of admitting we were wrong, and we don't want to admit to that. So why would we admit to a new case?
Yeah.
But yeah, the Section 101. Okay, for all of those out there that are going through,
it doesn't do much for the trust and confidence now, does it? And we all know that's what government needs. Trust and confidence.
Yeah, exactly. But yeah, for all of those whānau out there that have got a child that's under Section 101 and have been led to believe that it is home for life, it is only home for life because you don't know that you can apply under Section 125 of the OT Act to discharge those orders. Okay, if you want a slightly faster avenue and you're representing yourself, or you've got a legal aid lawyer. Okay, yep. The other faster avenue is under the Family Court Rules 2002. You use Rule 34C to vary or rescind an order, which is you're really just applying to rescind the order. Okay, so discharging the order means that the custody goes back to the last person who held it, but there's still that chance that they can come back again. Okay, rescinding the order rescinds it out altogether.
Yeah.
Okay, and so
I'll point out what you're saying there about home for life. Section 101 custody orders. If a court on application under Section 68, as you were saying, and then 14 and 14.13, yep. Is satisfied that a child or young person is in need of care and protection, it may make an order placing that child or young person in custody of any of the following persons for such period as may be specified in the order.
Mm-hmm.
Where does it say home for life in that? It doesn't.
Yep. The other thing that also comes into it, okay, that a lot of whānau will not be aware of, okay, if you go by Section 126, okay, there's also cultural social services that can apply for the custody, iwi that can apply for the custody, okay, yes, Salvation Army groups can apply for the custody.
Oh, there's
okay, and okay,
a subsection A, you've got subsections A through to O, so there's quite a few.
Yeah.
But yeah, I is any iwi social
and so
cultural service.
Yeah, and so where we are led to believe that only certain people can apply, any like, okay, Presbyterian social services, okay, your Catholic social services, all of these agencies, okay, can apply to the chief executive to take over the custody. Okay, now the reason that I believe a lot of them don't do it, like Salvation Army do, they actually take on Section 101s. Okay, we got a local place down here that doesn't. Okay, and he said, like the guy that I spoke to here, because I found out from someone else that where it was and that, and so I rang it and spoke to the guy, and he said, yeah, well, what we try and do is, okay, Section 101, a lot of these mothers, they've done nothing wrong. Okay, but what it is, they've had a newborn baby, okay, and they're still using Section 18A, which is supposed to be repealed, okay. But if you look at Section 18A, they're getting away with, it's funny I say this, but the 18A, if you look at it, under 18A, it says 18B applies, which is you can't have your subsequent child if you have done murder, manslaughter, or child infancy, okay. Now, 18A doesn't get implemented on its own. You require 18B, one of those categories, for 18A to be implemented. However, what do? They just go under Section 18A, we are taking the subsequent child. Why? Because people are unaware that 18B is required for 18A to be implemented.
And that's a person.
So realistically, we have newborn.
Sorry, who is?
Yeah. So we have newborn baby. Yeah. So 18A is subsequent children, but subsequent children only applies if it's murder, manslaughter, or child infancy.
Which is where 18.
And so you see, what's ending up happening is we have all of these newborn uplifts at the hospital based on the fact of, well, there was family violence. Okay. Well, I'm sorry, but the last time I looked, family violence wasn't murder. Okay. Have you been convicted of murder? Have you been convicted of... That's right. So if it's not part of 18B, 18A doesn't apply. You know, so we've got whānau out there. Like, I'm dealing with a young mother.
About us about face the way they've done that. You know, you'd expect 18A to be the person described in the section, and then 18B to be subsequent child removed. But they've done it us about
Exactly. And so what they're doing is they're turning around and using 18A to uplift the newborns based on the fact that you had another child taken. 18B doesn't say because you had another child taken. It says you murdered, you manslaughtered, or you've hurt a child badly that nearly killed them under 1 year of age.
Sounds like our friend down in Ashburton's type of thing, isn't it?
Yes, very much.
You know, they're trying to bring in the old family violence thing.
Yep,
So
exactly.
It doesn't matter.
Yep. No, and I mean, like, okay, in regards to that one, I mean, like, that's pretty much, their case is pretty much destroyed anyway because of what we've done. So,
Yeah.
but it's one of those things where parents are being judged just because of the fact of, okay, there's something wrong that happened with the other child, okay, the last child you had. So we feel we have the right to come and take this one, even though what happened to the fact, okay, if it's like, say if they're having a child 3 or 4 years apart, okay, who says they didn't change in the meantime? I've got a good example of one I'm dealing with in Auckland at the moment. Okay, she had children when she was young. Okay, had a few problems when she was young. She's gone and done the courses herself. Okay, and got herself better. But that's not good enough. We'll still take these children, and they've done this. They've done her one on a 101. But here's the funny part. Okay, we're going to fight that because of the fact that, okay, when you turn around and say baby with the surname, when that child's born and is given a name, that's no longer that baby. That's no longer that person on that order.
Exactly right.
Okay. So they, on her case, they came and they took the baby, okay, 2 weeks after the baby was born, on the fact that they had consented to a 101 when she was 5 months pregnant. Okay. But that's not their child.
No, that baby has a new identity. The baby doesn't exist anymore. It's been replaced.
Exactly. And it's like when you get parents that are going through these uplifts, the most important thing that they can do with an uplift, okay, we always go to fight the custody order. Okay, so if we're already past the uplift and they've got custody, they always go to review, either judicial review or appeal the custody order. Okay, in my view, you are much better off to appeal the review or appeal the uplift, and the reason for that, okay, is because at the time of the uplift, you as the parent still had that custody. So if you can get that reviewed and overturned, the custody comes straight back to you.
Exactly.
Okay? If they didn't have good grounds for doing that uplift, then that's it. Okay, and you can prove it.
And what's the other little thing we discovered about that? Is if you actually goes back to the original warrant for uplift, then they've got no power or statutory power to defend.
What it ends up doing, from my understanding of dealing with this, is if you go back to the uplift, okay, they didn't have any custody orders, which means that you're back to the uplift order, and the uplift order, because it's only a warrant to uplift and there's no custody attached to it, that removes the statutory power. So once you remove the statutory power, that makes it even harder again for them, because you're back to common law and you require the statutory power to be able to implement the acts or the legislation. So if you go all the way back to the actual uplift, okay, they have no act in New Zealand law that they can use because you've removed the statutory power by reviewing it.
It's indefensible. It's indefensible.
Exactly.
They're screwed.
Well, one would think so, but when it comes down to it, let's see what happens with a case when one does happen, because at the end of the day, they'll always try and find something, but it's one of those things where Whānau just got to be aware of the fact of what you can and can't do, okay, more so what you can, because they already tell you what you can't, but you actually can. So hence the reason why we're doing this. Home for life, people, is not home for life. Home for life is only home for life because you've been led to believe it's home for life.
And basically, they've made you give up. It's basically it.
And a place of safety warrant can be fought with a notice of intention to appear. So if they come and they take the child away by force, like they do, okay, the best thing you can do.
Yeah, we've seen the uplift of yours. It's up on the channel.
Yep, and there's been other uplifts where they just grab the kids, okay? If they've grabbed the kids and they've taken them straight down to the courthouse and file a notice of intention to appear in regards to that child's case. Yep. Because if you can get down and get that done, okay, that stalls everything, because then they can't just go and get the 78, the section 78(1), which is interim custody, okay, until such time as they can get full custody. Okay, most of the time the court
and by filing that application to appear after the child's uplifted, you're keeping it still in common law because there's no orders that's been made. So the only grounds they have is that warrant, which they can't statutorily defend.
That's right. And at the same time, if you're under the OT Act, then you use section 82/2 and 3. Okay, and what that says, okay, people, we had put this forward at one stage, okay, and got told no, it wouldn't be possible. 82/2 and 3 says that until such time as things are heard, that you do have the option of having the child returned to your care. Okay, so the easy way of being able to try and implement that the best you can would be to turn around and bring it up in court and turn around and say, we'll make an application to apply for that, based on the grounds that, okay, yes, it was put in front of the court that this child was needed care and protection. You put in a notice of intention to appear. You filed an application to have the child returned back to your care until the court has heard the evidence in regards to it.
Correct. Yep.
And the thing is, what will happen, okay, is a lot of whānau out there, they'll do the same mistake that we did, okay, and it is this. We asked OT to consider that, okay, not knowing that we could file in the court and ask the court, okay. So my answer to them all the time now is, okay, well, this is what we're looking at doing. Oh, no, you can't do that. I'm not asking you. This is going to the court, so the court can decide. You put your evidence and we'll put our evidence and we'll see where this goes.
So
because at the end of the day,
so basically the ball, being the custody, is in the hands of the judiciary, as opposed to in the hands of the other opponent. If you're playing a sports game and the other opponent's got the ball and you go asking for it, do you think they're going to give it to you?
Exactly. Whereas
if you ask the ref, who's supposed to be independent, and he sees the evidence, well, then there might be a different outcome.
Exactly. And you see, the thing that whānau have always got to be aware of is this. Okay, when you try and put something, when they put something in, okay, always remember section 71, no matter what they are applying for, they don't have to put evidence in. Okay, they are not bound to have to provide evidence to be able to get the orders.
And section
that is the part of their act.
Section 71 is the court may make care or protection order in absence of proof of responsibility for neglect or ill treatment of a child or young person. So they don't need the evidence.
That's right. So they don't need to put any evidence in. All they need to do is put an application in, okay, and they'll be granted the orders because the Act says they don't have to have evidence.
Unless you put an application for a notice of appear, and that fucks them.
And that stuffs it up because all of a sudden, okay, you've taken that 5 days with a place of safety warrant. If they're just applying for a 78 or a 101, 7 days, you've got to do the notice of intention to appear. Okay, but once you do that, that slows their proceedings right down. And this is why they get away with it so often, because nobody knows that they can defend themselves and their child and go, well, hold on a minute, I want to appear in regards to that. I haven't been heard. They've only put their side forward. Yeah. And so that's where the most important part of the acting is, as a whānau, is get your notice of intention to appear in, because if you don't, they're going to get the order.
Yeah, and it's one piece of paper that you have to file. And
then from there, the only way you're going to be able to do anything is a judicial review or an appeal. Okay, and so depending on how, like in the family court, that can take 3 to 12 months easily. Okay, but what we found in the High Court is that same time frame came down by what do we put it down?
Well, from months
came down to 42 days.
Yeah, from
42 days.
Yeah, 7 weeks.
Yeah, and if you do an appeal in the High Court. The other good thing I would like to mention in regards to going to High Court, okay, if you're self-representing, unlike the family court where you're dependent on what the lawyers are talking about, okay, if you are the applicant, okay, then there are certain rules within the High Court that say that you must turn around and put down the time frames in your notice of proceedings to say, right, okay, for instance, the OTQC, because it'll be a QC that deals with it, okay, you put your application in and your evidence in, Okay, from the time that you've done that, they then have 15 days in which to respond with a notice of proceedings. So they've got to be able to respond to say what they're going to do. From then on, okay, you've got another 15 days to respond back to that. Okay, and then after that, it's a 7-day period for the bundle to be done. And if you're clever about it, what you do when you write up your notice of proceedings is you put it in it that the QC from OT is going to prepare that bundle. So that way, all you've got to do is email your evidence across and make them do all the work. And then what happens is you then go into court, and they've had to do all the work.
Yeah.
Yeah. And you
Takes all
see,
the hard
by
part
the
out
time I
for
worked
you.
it out, by the time yeah. So you've done your evidence and everything, okay. But the person that's doing the application, okay, they choose who does the bundle. So if you get experienced by that time, you can do the bundle yourself. But in the meantime, why not make the QC work that's come on board? And because when you put in a judicial, like for instance, if you do a judicial review, you got your judicial review paper, you got your statement of claim, and you got your notice of proceedings. Okay, to file each document is $1,350.
Cool.
Okay, but if you are on a benefit, you only need a printout from WINS, okay, and a fee waiver, because for you it costs $540 to put the application in, okay. But as long as you're on a benefit and you can show the letter from them stating this is what you get a week, no fee. Okay, so you go into the court, you're filing your documents, you don't have to pay anything because you've got fee waivers, okay. So OT is filing, okay, the other parent's filing, okay, and on average I worked it out, per the 3 lots of documents you got to put in each time, it's roughly $4,050 every time you got to file.
Wow.
For the other part.
And of course you're not paying, but I'm sure the court backhandedly is probably getting some money out of the Sister K trust that's been set up.
Probably, yeah, because of the fact that what happens is, okay, on top of that, it's also got to be, I think it's, what is it? It's between 480 and 1,200 or something per hour for the court to hear it.
Yeah. Yeah.
But because you've done a fee waiver, you don't have to pay for it.
Mm. So who does?
Yeah. And so, like, even if you go in with an originating application, okay, if they don't grant the originating application to bring it into the High Court, here's the bonus for you, okay? Okay, in some cases, like ours, okay, no date given, okay, but fill out an originating application, and in less than 12 hours, you've got a date. Why? Because the family court don't want them knowing what's going on up in the High Court.
Yeah, yeah.
And so, even if you don't get the originating application,
let's put some expedience on this, because we really don't want mummy and daddy to look at what we're up to down here.
Exactly. And so, I think to me, the originating application is worth the application simply because of the fact that if you're being mucked around, it gets you a faster date. Yeah. And, when you go from absolutely no date and you're looking at well over a year, I mean, I've been seeing cases lately where people are saying, I've been waiting 3 years to get into the family court for a hearing. Okay.
So much the right for a speedy trial sort of thing, isn't it?
Yeah, but I mean, when it comes down to it, fill out the originating application, put it in, okay. It seems to be, for some reason, easier in the North Island than it is the South Island. I don't know why. Okay, but that's what we've been finding.
I think there's something in the water down there, eh? Well, not in Timaru.
Honestly, I'm starting to originating applications for the South Island. If we shouldn't just put a picture of a can of space, might get through that way.
I mean, I'm from Timaru, and I know for sure there's no fluoride in the Timaru's water supply. Thanks to my mum.
You'll know. Is there definitely a High Court in Timaru?
No, Timaru District Court, High Court's up in Christchurch.
Oh, really? Because I was looking on the computer the other day, and it said District High.
Oh, they might hear both, but it's as far as I know, it's always just been called the Timaru District Court, but they may have High Court hearings in there as well.
Oh, right, okay.
It's all changed. When I went down there a few months ago, Timaru's courts changed completely from when I was down there. But that's 20 years.
Fair enough.
Yeah.
Yeah, okay, yeah. But that's what I think whānau need to be aware of. There was something else I wrote on the other page too. Where was it? About Section 71 of the Act, because I honestly believe that, okay, what whānau are going to find out there is, okay, you get pulled into the family court, okay, when they come to your house the first time and they've got their report of concern, okay, if you don't want to speak to them, that's all good, but here's 2 questions. what are the care and protection concerns? Doesn't matter where they came from. What are the care and protection concerns? When they tell you, what evidence do you hold of it?
Yeah.
Okay. The minute you turn around and ask them about that evidence, they will back away because they are going on. Okay. Just like that's right, and because of the fact that okay, someone's made a report of concern, okay, and it's hearsay until such time as there's any evidence. Where it goes wrong is, I honestly believe, and I tell everybody this, okay, if you know you have done nothing wrong, okay, don't accept it. Simple as that. Don't accept it. Take it to court.
Yep.
Because, okay, what they're trying to get you to do with the FGC is they're trying to get you to admit, yes, there are care and protection concerns. Okay,
yeah,
and the minute you go,
that's what the foregone conclusion's all about, isn't it? Sorry, the FGC foregone conclusion's all about.
Yeah, but so what ends up happening basically is that okay, is the minute you go, yes, we agree there's care and protection concerns, well, you might as well just hand them the keys to everything.
Yeah.
Because that's what you're doing by saying that. And because you said there's care and protection concerns and you said yes, what happens is when you get to the court, even if you're trying to defend it, all the judge sees is that you said you agreed.
Exactly.
Okay. Now, the other important thing, 1 to 8 plans that they file in the court. Okay. So many whānau out there would have had this where they file the 1 to 8 plan. Okay. As is the same in our case, 1 to 8 plan got filed. Now, here's where they get really cocky with you, especially if you're the protective parent. Okay. They will turn around and this is what they do. And I can give an example of this because it happened in our whānau's case. Okay. The uplift was done. Then they turn around and they put a 1 to 8 plan in place. Okay. They went to court within the 4 days of the uplift order, like they were supposed to, got the 78-1. Okay. Then when was it 2 weeks later? Okay, they had to file again to be able to have it redone again. But in that time frame, they had done an S1 to 8 plan. Okay. The unfortunate thing is, they included my daughter in it. She had no idea what was written in it because she wasn't part of it, wasn't part of the planning. Okay, this was all done while.
So what she's doing being included in it if she wasn't even.
Exactly. Yeah, and so what they did was they drew up the plan. Okay, and so that she couldn't fight the plan. Okay, the court date was the 16th of April. It ended up going to the 17th of April. Got moved a day. So they gave her a copy of the plan at 5 p.m. on the night before the court. No way to be able to fight it because you've got to be able to fight within 24 hours. Okay, 24 hours before. So what ended up happening was I got her to check up in October last year. Okay, because they had put all the stuff that needed to be done on the plan. Okay, and we found out, yep, it was filed, but it was never approved. So we made contact with OT in regards to it.
Yeah.
OT's answer, we never said it was approved. Then why the hell are you trying to make her do all the stuff? So I just said to her, that's it, you stop doing everything. Okay, you stop doing it altogether. Okay.
There's no agreement that's been made.
That's right. The judge, the court accepted it for filing, but it would never got approved by a judge. Okay. One thing about FGC plans, okay, is they can submit them to the court. Okay, but you will get some judges, like I know of one case where the judge turned around and asked them, so why is this on the plan? Why is this on the plan? Why is this on the plan? Oh, because that's what needs to be done. No, it doesn't. She doesn't need any of that. So the judge just discarded the plan. Said, no, you're not doing any of that.
Yeah. Good.
And I turned around and said to her, so what made the judge say that? She goes, oh, because she's known me for a while. I've been under the Care of Children Act. But as soon as we got under the OT Act, okay, I was required to do this, and this. Okay, and apparently the judge pulled them up on and says, well, I don't know why you're asking her to do all of that stuff because she just did it last year.
Yeah.
So the judge said, no way is she doing that.
So the judge.
But you know, when it comes to
the judge was familiar with the previous history of that woman.
Oh yeah. So she was pretty. It was a female judge apparently. She was very familiar with the previous history, and she already knew that she had already ordered her to do all that the year before. So she's saying the judge is saying to the OT, well, why does she need to do it again? She's already shown me the certificates. That's coming to the court.
Already jumped through that fucking hoop.
Yeah, I mean that's like another lady I'm dealing with. Okay, she's got the certificates, and they're trying to tell her, no, before your child can come out of a 101, you have to do these. I was like, no, you don't. And she goes on this, oh, but they said, I don't care what they said. You've done the certificates. You haven't gone backwards, have you? She goes, no. Right, you don't need to do it. We already got certificates there to be able to put on the file to show.
You do not listen to the opposing team. You listen to the fucking referee. He's the one that calls the shot.
The problem is when you've got so many whānau out there that have been going through it for years, okay, and all they've got is what they're telling them, they don't know any better. That's the problem.
Yeah.
And so this is why I suggested we do what we're doing now, to give them the knowledge of how to be able to get back out of it. And the fact that
I think there's going to be a lot of families in New Zealand that are going to be very happy to know this information.
Oh yeah, definitely, yeah. And I mean, when it comes down to it, the more information that they know, the better. And that's why I say, okay, at one stage, because I'm not so much up on the Care of Children Act. Okay, that's why I've been helping our friend down in Ashburton. Okay, and so I've been learning a bit more about that. But yeah, I mean, like, something's up when a person's been trying to get back into court for 18 to 20 months. Okay, and finally got her back into the court.